ebusia for Ghana Politics Avenue and Masukusu Amuti ha ena political trending news the echo any day baby and yeba aba besom na ene obi bebusa ye call political hiring so dey ene your dem ya bedwafo nsem bebre ena boboba the maswati ene de masonti na ene yekofa ade abrem kwabna the quadrate edu Boahene the court ni insensem akodi court omo edi hu akone aba ne ade no ene court of appeal enso ede aba betudwa actually mu biem say omabusa for evidence ede free attorney general over and over and over again no ene busa for your project ede atom screen so motion omabusa for evidence over and over again every attorney general na wo say asemasi ede ansem bi na so waye boni bi wo de naba appeal say ubedi na asem na dey na wo editia na untimi enfama na the court of appeal no believe say attorney general will be bia on famra na emboa ono animu na emboa case na so ode aba beto momo na busia for mpese mejimo brabo so no fair aid trials and a court of appeal can Dominic Ayeni say onfa evidence owo editia kwabna edu Boahene on submitting famra na omuntimi ndi asem no intentem so meda obi biase ha Ghana Politics Avenue so yenko ti DC meda obi biase.
If you recall, sometime last year, the Attorney General did a huge media theater in which Boahene and the wife were condemned as criminals, having stolen 49.1 million Ghana cedis under the guise of buying a cyber defense system for the National Security Secretariat. In fact, the Attorney General even concluded they are so guilty they should come for plea bargain. If not, it's a serious matter for them. Now, they went to court and they are supposed to make what we call disclosures. What are these disclosures? These are the documents the Attorney General will want to rely on to prosecute the case so that it don't spring a surprise on the defense. It also means that they might contain documents which are exculpatory of the accused persons. That is to say, the Attorney General should not hide any document at all, because some of the documents he would have will be consistent with the innocence of the accused persons. All that we call disclosures are firmly embedded in Article 19, where we're talking about fair trial. So what had happened? We asked for disclosures before the High Court judge. The first in time was Justice Nyante Nyadu, and he refused us the disclosures. And because Boahene is not feeble, but a very strong national security person, he said we should go on appeal. And we want on appeal. And today, by the unanimous decision of the Court of Appeal, this is the quorum. Mensa Dache, Mrs. J, presiding, Buadi J, Ama Tete J. They came out with this decision and made the following orders. And I want to just go through the orders that were made as quickly as possible. The Attorney General reheld pages 2 to 89 of the Advantage Solution Company Limited's bank account. So they put forward the bank account, but took out pages 2 to 89. The Court of Appeal said that is wrong. They should disclose the rest of the missing pages. Now, the Attorney General has not disclosed the source of the 49.1 million. Because if we come to terms as to where the 49.1 million is coming from, then it will be consistent with an argument that state funds has been stolen. So the source of these monies, there's a clear order that, they should, disclose. We requested for confirmatory evidence from IS Holding Limited as to whether or not the cyber defense system has been delivered. By reason of we using the word confirmatory evidence, the Court of Appeal said we should reword it and be direct what we mean by the confirmatory evidence, and then we can ask for the disclosures. So we're going to do the rewording and then ask for the disclosures. Another matter which is of very, very serious importance for us was the delivery of the contracts covering the cyber defense system. And that's a contract between the National Security Setup and IS Holdings Limited, that Israeli company. The court also said we should reword what we mean by confirmatory evidence, and then the request should be made to us. There was a direct order to the national security space that we wanted to have photographic evidence of the cyber defense system. We wanted to be sure whether the cyber defense system was there. And here also, we were not denied that we should go and say it, but we should reword our request to see the gadget or a combination of gadgets, and that should suffice. Now, we also wanted to see the file put together by Joshua Chairman, Ghana's the then National Security Coordinator, relating to the acquisition of cyber defense system, which is a prominent dimension of this criminal case. And then the court said, if the file is there, they should release it for us to peruse it and use it to aid the appellants. On the contrary, there's a huge largesse of victory that has been secured by this decision. We've not lost that. Or in fact, the Court of Appeal said we could reword some of the things to make it clear and then ask for disclosures. So it will be contradictory in terms, and I'm sure those who are, the workers of iniquity will be parading that we've lost this, appeal. But what we are going to do is to put the full appeal in the public space for people to consume and see that justice has been done. Because what they did is upholding Article 19 of the Constitution. If you are unable to even show the purpose of the 49.1 million, and you thought it was for the importation of a cyber defense system, and the case has collapsed. So a lot of things will be done. Some of the witnesses should be recalled to come and address some of the concerns that will evolve from the disclosures.
In oral and the updates that you've been providing, there's one that is of particular concern, that Kwabena Boahene case and the security entity. The lawyer for the defense seemed to be of the opinion that they are winning that case and the AG is bottling it.
Well, it is the belief or hope, or let me say the desire of every defense attorney that the prosecution fails and they succeed. To that extent, I wouldn't be much, because he's defending the person. It means that he believes that he has a defense. But considering, I am just concerned about the level of his conduct in the media on the case. So, for example, he will come and threaten that when we bring a particular witness, he's ready to finish that witness and things like that. I'm not sure if those things are particularly ethical to be, even before the witness can, you are telling the public that you are going to finish the witness and all that. But it's a simple case as far as we are concerned. There is public coffers. You move money from the public coffers into a private account. And we have produced evidence of that transfer, which is by checks, 3 checks. After that, from that private account, you have spent the money in purchasing property and other things for your personal benefit and for the benefit of your companies and your friends. We have evidence to that effect, which we have put before the court. And we said public money is not supposed to be spent that way. And anyone who spends public money that way is either charged with stealing or causing financial loss or money laundering or any of those offenses. That is what the case is about. We have, through the cross-examination, seen a number of things that the defense has been trying to do. First, they began by trying to show that there was discrepancy between the dollar and the CD, values at the time, which for us is neither here nor there. It's a different thing if we accuse you of stealing dollars and then we converted into CDs and charged you. Then you can say that the conversion rates will reduce the amount. But in this case, it is CD it's the CD account. So you move CD from the public coffers into a CD, private bank account. So the long cross-examination about CD dollar rate is neither here nor there. Then when that collapsed, they now moved to an area where they were trying to say that the accused person usually gives loans to the public organization, and suggesting that the 49 million, which is the subject matter of the thing, is a so-called repayment of the loan that he has previously given to the institution. So basically saying that the institution was paying the loan back. That didn't go anywhere. Recently, there was a suggestion through cross-examination that the account which we are calling a private account was a secret national security account in which the money was being sent. We don't know what that means, because if it is a national security account, we will know. So that one didn't go anywhere. Then I think the recent angle of cross-examination seemed to suggest that the equipment which was supposed to be bought with the money
purchased
has been purchased and is there. But we have tendered in evidence. We have filed as part of our disclosures the inventory, which shows that it wasn't there. The last time I checked, they have filed to go and inspect the inventory. So how is our case weak? Because the core allegation of moving public money into private account and spending it for personal purposes has not been damaged by any of these.
You believe they are publicly doing this to create a certain perception in the minds of?
I believe so, because I believe they're actually succeeding. And I have a certain standard ethical, I don't think I am a public official.
Right.
I owe the public explanation on everything I do. Okay. But I also don't think that it is fair to the accused person for me to come out of court every day and be saying things from my perspective. If you do that, you are oppressing the accused person. You are also likely to misconstrue, because you are speaking immediately after court from your perspective, which may not necessarily be the objective perspective of what happened in court. So I don't think that is something I want to be doing, but I also don't blame anyone who wants to do that, even though the rules of ethics of lawyers doesn't support that. But I also understand why some lawyers will be doing that, and I have no problems with that. But, well, I believe that the outcome of the case will not be decided by public opinion. Of course, public opinion has some role to play, but its role is to make the prosecution look bad and appears that we are not doing the case. But like I said, this is the case we are prosecuting. We have filed our evidence. So far, nothing has been disturbed as far as our understanding of the proceeding are concerned. So all these arguments, there was a time where our witness was reported in the media for saying that they are not aware, that she was not aware that any money has been stolen until Yoko came in. But is that not what happens always? I mean, stealing in organizations, is it not always the case that when you finish and you are out of the office, then the next investigator comes to see that the money, nobody steals money and puts it on record that I've stolen this money. So I thought it was natural that she wouldn't know until
the investigations revealed it.
But it was a big issue in the public, and there was a celebration that, well, if the person who is managing the money didn't know that the money is lost, then it means that no money is lost. But I thought it was straightforward that anyone who is managing, if anyone who is stealing money will not steal it for you to know. And sometimes it may never be discovered. And sometimes when it's discovered, it will probably later. So I don't know what that was supposed to achieve, but there was a whole jubilation of that in the media by obviously people who believe in that angle of the issue. So we are focused. we are on track. We believe that we can secure conviction. Of course, I mean, we are doing prosecution.
Right.
We will put, and the nature of prosecution is quite a straightforward issue. We have evidence that we believe that this has happened. The court will give us the opportunity to present our case. After that, if they think that our case doesn't even make sense after we present, they will dismiss us, say that we've not made a prima facie case, and then everybody goes home. If we cross that hurdle, what it means is that, like in the Wunchumi case, it means that we have put sufficient evidence on record to the extent that if you don't give us a sensible explanation as to how these things are
create doubt as to the
as to what we have, then you will go, you will be convicted. That is how it works. So if we, after our case, the accused person is able to show that he bought equipment, but it was somewhere that we didn't see, or that he did this, or that the money is whatever, and is why? We are not here to by force convict somebody who has not done anything wrong. So we are ready to go through the path to the end. But we believe that we will get conviction. That is our belief. If we didn't believe, we will file a case in the first place.
Should be a Ojebre Jumedi. I know Ghana Politics Avenue. So, like Jumedi, and share, subscribe to the channel, and send a political trending news. The echo, and the Ghana Politics at Japan. So, I be bravo, Nabedra for any the T4. Now, coupon on show be an answer. Oh, and some Kaimi, so I share comment section. Send a Ghana Politics. I be for a Bejabre, not the Ontia Sibian, or more Archer, was here. Hannah Medumisi, Macron.